to testify. You recall that when we applied for interrogatories, that is, we wanted to administer 12 questions to her that we thought were relevant and necessary in advancing the case before the court. She swore an affidavit in which she said the interrogatories should not be allowed, and that when it comes to cross-examination, those questions can be put to her. In other words, she at that point in time evinced an intention to be cross-examined on whatever evidence she was going to give before the court. Then also, when we wanted to inspect documents, you remember we served notice on her to inspect the original documents that served as the basis for her declaration on the 9th of December. Again, she swore to an affidavit in which she said the court should not grant us the leave to inspect the original documents on the basis that if it comes to cross-examination, we will take our turn in impeaching her credibility in looking at those documents and their relevance to the case. And then also, during case management, orders were given for witnesses to file their witness statements. Again, Mrs. Jane Adukwe Mensah filed a witness statement in the matter, basically again saying that she was going to give evidence. So the point that our lead counsel was making today was a very simple one. There is evidence on record showing that she had elected to give evidence and to be cross-examined on the witness statement that she has filed. Now, we will not go into the merits or demerits of what she has filed because the court is yet to give its ruling on that on Thursday. But suffice it to say that the reason why we are insisting that she be allowed to testify is simply because, my brothers and sisters, this is not a debt collection case. We are not here dealing with a private matter, the private interest of private litigants. We are here dealing with the public interest. We are here dealing with the declaration of the results that reflected or is supposed to have reflected the sovereign will of the people of this country. We are here dealing with Article 1 of the Constitution that says that the sovereignty of Ghana resides in the people of Ghana, in whose name and for whose welfare the powers of government must be exercised. And so, for her to have declared that the sovereign will of this country as expressed on December 7, 2020, elected Nana Addo Dankwa Akufo-Addo as President of the Republic, she has a constitutional duty to account to the people of this country for how she arrived at that conclusion. And that constitutional duty means that she cannot, under any circumstance, be allowed not to account to the people through cross-examination, because cross-examination is one of the mechanisms allowed by law for exacting accountability of litigants. And this is not an ordinary litigant, as I've said. This is a constitutional office holder. And so our case is very different from some of the, even the English cases that were being cited, are of no moment when it comes to this peculiar matter that we are dealing with in court. So I'll stop here and take some questions.
So, Counsel, let me ask the first question. The impression that we get from the sitting of the court today is that there is somewhat a time-tested principle of where witnesses have the option of saying that they would not testify, but there seemed to be an attempt to say that that time-tested principle should be set aside and a new order should be introduced. Is that the impression we should get?
That is far from being the case of the petitioner. The case of the petitioner is that at the point where a decision had to be made by the Electoral Commission with respect to whether or not to testify, they made an election. They decided they were going to testify. And the rules are very clear that when you have elected to testify, you can't walk back from that election. And that is what we want. We want the court to hold her to that election that she made, both in terms of the affidavits that she swore before the court, basically pointing to our right to cross-examine her when it comes to her evidence in chief, and then also the filing of the witness statement. That is itself is concrete evidence of that intention to be cross-examined. And again, as a public officer, she has to account to the people of Ghana, and that is why we want her to take the stand.
Okay, sir, in most of the proceedings, the panel seems to rule that the legal counsel for the petitioner is not hitting the threshold to make this case relevant. Why then don't you rather...
I can barely hear what you are saying. Can you...
Okay, in most of the proceedings, the panel seems to rule that the legal counsel for the petitioner is not hitting the threshold to make this case relevant. Why then don't you rather, with the greatest of respect, channel your focus on the amendment of some of the constitutional laws and, as a matter of fact, CI 126?
I don't know what proceedings you've been watching, with all due respect, but the panel has not come to that conclusion. Not at all. Arguments have been made, and in fact, the respondents themselves have walked back from those arguments. You remember yesterday, they said something about a submission of no case. And I do remember that MPP communicators went, Bizek, they went to town saying that they were making a submission of no case, we had not crossed the threshold of the burden of proof and so on. Today, you saw that upon serious reflection, they walked back. They are not, because the consequences of a submission of no case are dire for them. They know that when they make a submission of no case, all right, then they will have to strike out their witness statement, their pleadings will have to go off, and the petitioner's case will stand uncontested, and all our release will be granted, which means that His Excellency JM will be sworn in as President of the Republic of Ghana.
I recognize the significance of the ruling that we are all anticipating. Are you able to share with us the effects on your side, whichever way this ruling goes?
No, we will not engage in hypotheticals as far as the ruling is concerned. And again, we don't want a situation where we are commenting on the outcome even before it has come. All right. The famous quotation from the court now is, when we get to that bridge, we will cross it. We hope that the bridge will be there when we are getting to it. All right, thank you very much. See? Okay.
Abusafo yabeda munyina masibiem na say about the ne akoso court tofa e wetwi kasemu a the medical can say the ne akoso court ene the nra yehun wo court no e ya nwanwasem kese pa enti a meka sa ne say Ewra John Dramani Mahamadi asemi ebeto Supreme Court animi isi for the omanu ye aba the ne sa hye sakrata na se eye banodani ma isi chairperson Jim Mensa ono and so ye the returning officer for the 2020 presidential election. Or then sa hye sa anu ye na se wie ye no wa ye the lawyer for friend no affidavit of verification say adanse ana nanu disem wo dia to court nanim ni nyina ye no kwasem ewi akira ye be case management a court ma order say isi for adanse for do say na mo be frɛ mo se ba ko mo adanse ni hwan a mo si Mensa the chairperson court ma order say by a certain date on fa na adanse kratamra 22nd January 2021 yema mi de ne sa hye na adanse kratasia or dia court nti ordene answer ba with affidavit of verification or the witness statement aba na dance krata aba eno so statement of truth the akire nyina ne say adanse e was akrata na so bibia ye no kre ebiem yegusu aye case management mo be kaya lawyer Chachuchi Kata lawyer for the petitioner extra court ne say omoma ye misa Jim Mensa nsemfua be edu mienu na sa anu ye ne be boa ama no kre was asem we mu no ene atentrene aye adwuma Yamami G. Mensa anuye in opposing this request, no. The Okai and say, and my court no or done say on answers our questions, no, because John Mahama and a lawyer for Benya Kenya during cross examination and Bisana Sans and Bisanina. Next, she say, G. Mensa on different occasions, not only in her answer and answer the witness statement, but affidavit here adansia was swine ama court no nyanti ase se obeba daka ni mu abedi adanse ne ye wasem bia ye bisa no afa enra John Mahama awie ndi case na dance for miensa nyina di o madanse awie omunyina wura daka ni mu with akukodro answer all questions are all sides the respondents had for them because omunim se no kretrodo no moka ana omunim se omutim fita edu ye maame so metena daka mu a ye maame se adaka ne pa de on tena mu ne entena mu kina wasesa na adwen on ma daka ni mu na dance krata no ono an de ba ye se de akura se maka menwe yenti no ye mfa na de ma no mfa nkofie oni dance ye adan na wo mpese oba be dia dance ye na ya toto wano na ya bisa wonsem because in 2012 Owura Farijan eba court to defend the constitutional obligations and to show say abatwa sambre no ka say John Mahama we no wa we ni ampa answered all questions enti wonya boni bia why wadwuma kama adenti na akonta mredru udwane na eno ho asem ne yababeka hu say ye insist through our lawyer say court no enhye maame no na ometena daka no because ono ankasa obi amfa tu ansi ni tuso ono ankasa ene ka kire court ne se omommo saa ye interrogatories ne saa ye nsembisa no ntontwene because obetena daka ni mu a saa nsembisa ni nyire betimi abisa no. And so having intimated that to the court no on to me sanso nsesa na adwen gaze ene de memmabiem na de lawyer kra won se sebi onye dansi ni bia keke. G. Mensa is not an ordinary witness in an ordinary case involving private interest. Or yet, the constitutionally mandated person, ono na batwa ye nyina na esi ni na so obobo results na bibia woni tim. Enti echinyagye aba figures wunyina no ono pe na obetumi eyi ano. Na busiafo ebia na munim de enti G. Mensa on person be wura daka ni mu no. Na mo meyan kan kire mo. The entire G. Mensa mpeso be wura daka ni mu ne se onim se na komam declaration na wa ye ya court ne se o hwehwe ma hwese per that declaration and the figures in the declaration no o mampenya kufu adu nya more than 50% no G. Mensa nim se wontimi justify G. Mensa nim se na asem wa waka no radio so ni in the media say wa ye correction of the mistake no enya no kore obetena daka ni mu a ye bepa na wontoma she will be exposed because the ever changing figures ahodo nsia no ebegu nanimu ase ama Ghana fo nyina hu se onye no kwafo e BMG Mensa nim se from 13 na ode aye ne exhibit 4 which is the presidential declaration form one ne lawyer say of failing on 9 December e de tare dan ho wo ba bia o ye declaration no onim so otena daka nimu a e hu nsem bisa beba e bemma na da di se sa form no enye papa. She knows she'll be confronted with questions about the authenticity of that form and she cannot justify the authenticity of same. And until na wojana no. And until mamuntie de ebinumo ka say oh NDC for na John Mahama ntimi nye case bia that is why G. Mensa says ma. Ye case I dey ba court no is simple. Why a declaration? Per wa declaration o mampenye kufu adu enya more than 50%. One kasa wa gel to musa wa yemfonso. But ye kasa nei u declaration wa ye nyina ye ba ko pe. Nsachira ya wa ye no mu bia ni wa. Wo de won sa sha ase amana be ye mra na wa gazette. There is only one declaration. And it is that 40 declaration that has been enacted into CI 135 and has been gazetted. And some fonso ni nyina no G. Mensa na nkasa gel to. Omo corrections omo so ma ye ni nyina no e anadwo ma na because figures ni sisi so. And even if a correction papa mpo a ye declare ye enact ye gazette ye. And we have presented a compelling and a solid case and MPP for him said they have a case to answer. Crocodile the John near the Roman and send your muye omusro. And you saw say the president of the bench at some point beside lawyer Kutampa say, now cry when you bra what you same way free. Oh ye Jimensa na easy for lawyer na. So it should let you know that because they were the beneficiaries of the unconstitutional conduct of Jimensa, any the easy for aye nintino. Omusro se maame no ebeba adaka nim. Eya sense ba ye jayama court. Na court de atemu no aba
yentimi anyanyansa sema misano sena ye na ye nimrugo
ai na ye de no yenya decision on ya woda na the general secretary ka ene say una o say NDC for ye ni asem bia we don't have any issue yentimi kura misa wasem papa bia because the case ni bogus ave adana usro let's not that kanimu na be expose how hollow our cases. This is not the time for her to run. She must account for her constitutional duties.